Good afternoon, everyone. Thank you for joining us this afternoon. We want to get started in a few minutes, but I wanted to start out with a few housekeeping items. If you're attending today, we do have your line set up muted, so you can rest assured in that end. But if you want to be extra cautious like I am, shocker, a lawyer with OCD, if you want to be extra cautious, you can certainly, it doesn't hurt to mute them on your end as well. We do have a Q&A chat feature that I wanted to point out. And if you have questions, we encourage you to please submit them through. We have over 400 attendees on the webinar today. Yesterday, we had over 700. I think some of you might be here today because we maxed out yesterday. And so it's kind of difficult. I can't make promises that we can get to every question and answer all of them, but I strongly encourage you to send them through. Our marketing team is on the line as well to help us navigate those questions. If I see them and they fit in, I'll try to bring them up as we go. Otherwise, we will have them available at the end and try to, get in as much as we can at that point. I also want to tell all of you attending to please be on the lookout for our thank you email. It will include the slides from the webinar today, so you don't need to be frantically taking a picture of every screen or anything like that. And it'll also include a link to the recording, provided the recording comes out quality, obviously. I mean, you always have technical glitches or a risk of technical glitches with these things. Yesterday, we were able to have a quality recording, so that was nice. I do want to point out our disclaimer at the top. I wouldn't be a good lawyer without a disclaimer, right? So we do have the information today is up to date as of this minute. And I wanted to point that out because yesterday, even the second we finished, we had to update our webinar slides again because the SBA came out with applications and guidelines that Andrew's going to talk about during our webinar. So, it's still a good overview in any event. Yesterday's webinar had, the bulk of it is still timely, but I just want to point that out that things are constantly changing. And, this is up to date as of, April 1st at 1:02 p.m. Okay, so if we want to get started now, today I have my colleagues with me. I'm Rebecca Dobbs-Bush. I'm a partner in the Labor and Employment Group. I work on comp and benefits where employment law intersects with tax. So ERISA, comp and benefits, all of that fun stuff. And a lot of this, as you'll see today, is strategizing your comp for your employees during this crazy time. John Tanzel, Larry Tomlin, and Andrew Pagorni are on as well, and they're going to talk about different things there in our finance group. So with that, I want to turn it over to John to talk about what we'll cover today.
Thank you, Rebecca. This is John Tanzel. I practice banking law. I've been doing it for 40 years. And appreciate the uncertainty creates so much anxiety for you. So what we want to try to do today at a very high level is walk you through what government assistance is out there in the CARES Act, specifically with the Paycheck Protection Program. We want to talk a lot about that. As Rebecca mentioned, during our webinar yesterday, the SBA finally came out with some guidance, and as it turns out, it really wasn't SBA, it really was Treasury. There almost seems to be a little turf battle going on between these two agencies. So this morning, Andrew and Larry and I were on a call with roughly 200 bankers talking about what that guidance said. So what we have today is, as Rebecca said, what exists at the moment from SBA and Treasury. So before we even get into the agenda, there's some practical things that I think are the most important thing you're going to hear today, and that is to call your banker. That's the very first thing. Call your banker. Tell them you want this loan. There's some it gets forgiven if you do it right, as Andrew will talk about. So what the banker is going to want to know is, were you in existence at a certain point in time? So start getting your organizational documents put together. Get your payroll documentation put together, your 944s and your 941s, so you can take those to the banker. You want to make this as easy for the banker as you can. Also get documentation on what your rent might be, what your mortgage is going to be. Andrew will get into how that all works down the road, but the bankers are still working through this, so also be patient with them. Until the guidance comes out from the SBA, the bankers are kind of at a standstill. So be understanding of that. And there is also, if you go out to the SBA's website, they now have a Paycheck Protection Program application form sample. It's not the official. It is only a sample. So take a look at that because it will tell you what you have to do, and Andrew will walk you through that as we go forward. So what we're going to talk about today, we'll talk about that Paycheck Protection Program, payroll tax credits that you'll get benefit from. Larry's going to talk about some additional initiatives that the government's coming with, both from Treasury and from the Federal Reserve. Then Rebecca will talk about the increased unemployment benefits, the loosening of rules as it relates to retirement plans for withdrawals and things like that, and then qualified disaster payments. So with that, Andrew, let's jump into the Paycheck Protection Program.
And one thing, Andrew, while I transition my controls to you, this is Rebecca. I just want to point out that the beginning part that Andrew's talking about, a lot of it is just for employers with less than 500, which he'll explain eligibility in a second. But I don't want those of you on the call that don't fit into that to despair, because the stuff Larry's going to talk about is going to apply to larger employers, and the stuff I'm going to talk about applies to employers as a whole. So there is still, even if you don't qualify for the Paycheck Protection Program, we're still going to cover stuff that you can take advantage of today. I think you should have control now, Andrew.
And Andrew, before you start, this is John again. There's one other thing I think is very important for you as a borrower to consider, and that is what provisions are in your existing loan documents. Some of those, as you are probably aware, have covenants against additional indebtedness. So make sure that those are either waived or they don't exist, so you don't inadvertently trip up and create an acceleration of your outstanding debt. Okay, sorry, Andrew, go ahead.
No, thanks, John. That's a good point. Well, good afternoon, everyone. I'm going to kind of highlight and start off here with some overview of this Paycheck Protection Program that Congress has enacted to more or less provide a form of loan so that we can keep people on employment, not on our payrolls, and not have to go through any furloughs or layoffs. As Rebecca had mentioned, kind of the principal threshold question to look at here is whether or not you qualify for the program. Under the existing SBA guidelines for SBA loans, if you've ever dealt with them, there's a pretty strict set of rules that govern eligibility. What Congress did here with the Paycheck Protection Program is to expand eligibility to all businesses that are not more than 500 employees, or in some limited cases, you might be able to still qualify if you have more than 500 employees. But this is going to depend on whether or not your primary industry is in a particular category. The SBA has some additional industry classifications where you might be able to have more employees. This is based on the NICS codes that the federal government sets out. Another potential exception to this 500 employee rule is if you're an employer in the accommodation and food services sector. This would be NICS code 72. In that case, the 500 employee threshold is based on physical location rather than an aggregation of all locations. A couple of really important points to mention in terms of looking at whether you qualify and that is kind of how the SBA counts how many employees you have for purposes of this threshold. The SBA generally looks at all individuals that are employed, whether it's on a full-time, part-time, or other basis in calculating this. This might also include some temporary workers or leased employees. It might also catch some 1099 independent contractors who may be independent contractors for other purposes, but for this purpose of calculating the threshold, the SBA might deem them to be your employee. Secondly is the SBA's affiliation rules. The SBA has pretty broad rules that define when one or more business entities are affiliated with each other. And what this is principally driven by is whether or not people, for example, if I controlled two different companies, those two would be affiliated. So they really look to a ability to control companies or have the power to control whether or not it's actually exercised in determining whether or not two businesses are affiliated. This is important for this calculation because when two businesses are affiliated together, the SBA is going to aggregate those employees amongst both entities for purposes of calculating the applicant's threshold. So if one business only has 20 employees, but an affiliate of theirs has 520, neither of them would qualify because in the aggregate they would be over that threshold. One exception to note on that is under the CARES Act, there is a limited waiver of these affiliation rules, but this only applies to businesses with the NICS code 72 or franchises through the SBA.
And Andrew, this is Rebecca, I just want to jump in. For those of you not familiar with the NICS code, 72 is food and lodging generally.
Right, thanks, Rebecca. And if the SBA, the federal government has those all published online, so those are publicly available if you want to take a look at those codes. And then just real quick, these are on the slide, but part of the expanded eligibility does include sole proprietors and independent contractors, as well as some other organizations. This primarily is going to be 501c3 nonprofit organizations. So if you go to your lender looking for a loan under this program, what are they going to look at? Under the underwriting standards set forth under the CARES Act, the primary conditions they're going to look at is whether the business was in operation as of February 15th and whether or not they had employees for whom they paid salary and payroll taxes. Banks, due to certain anti-money laundering rules, are also required to comply with a law called the Bank Secrecy Act, which is just anti-money laundering law. So that's something else that they are going to look at as well. That should be less of an issue if there's a pre-existing relationship with the lender. In terms of documentation, John kind of had touched on this a little bit, but for showing that your business has been in operation, we would recommend getting together your organizational documents, whether or not these are the articles of incorporation, articles of organization. These would be filed with the Secretary of State or similar entity, government entity, depending on what state you formed your company in. And then second would be to get what is called either a certificate of good standing or a certificate of existence. They're one and the same, but different states have used different terminology there. And then also kind of putting together your tax documents and other payroll filings with your federal and state regulators. A couple of important things to note here in terms of underwriting standards. The lenders are not required to see if you can get credit elsewhere. This is generally required for any type of SBA loan. There's also no personal guarantee requirement and no requirement to collateral with these loans.
Andrew, one of the things some of the banks are looking at because of the lockdown, in essence, that we're in, is if you do this, you put in an app, they'll probably set an appointment for you to come in, and how that all works, I'm not sure. We've had questions about whether there can be digital signatures, and the SBA has not yet issued guidance on that, but that's also one of the things that's being looked at. So I just want you to be aware that there are a lot of still unanswered questions about how the actual program will work, but it could end up making it easier for you. I'm sorry, Andrew, go ahead.
Yeah, appreciate that.
Oh, wait, Andrew, one thing while you're getting your slides to correct here, I just want to point out, this is Rebecca, I just want to point out that this is a huge deal, the no credit elsewhere and the no personal guarantee and the no collateral required, that makes this loan, even if you didn't get forgiveness at the end, which Andrew's going to talk about, but it could make this loan way better option than your existing credit lines, if possible. So I don't know why, if you fit into eligibility and you were less than 500 employees, why you would not look at possibly taking out this money and taking out the maximum available to you, because you could always pay it back if you didn't use it. I was telling someone this morning, you know, you don't want to count on being able to go back for seconds, right? If you undertake. So I don't know why you wouldn't. Those are huge, huge factors. Thanks, Andrew.
Right, of course. A couple of other points on kind of what a lender will look at in terms of underwriting, and this derives from the sample application that John mentioned that the Treasury Department issued yesterday. And the part of the application is making a good faith certification as to the the items listed here on the slides. These are summarized. More detail is of the certifications provided in the application, but a couple of points to make on that are really these first three. One is that we've had a lot of clients ask us about whether or not there's some type of revenue threshold. So, for example, if the business is still doing well, can I still qualify for one of these loans? And our response is, well, there hasn't been a specific underwriting standard in terms of revenue or profit that needs to be met, but borrowers are required to make this good faith certification that the loan is necessary because of current economic uncertainty. Now, what exactly that means, we are hoping to get a little bit more guidance from the Treasury or the SBA, but as of today, there's not further guidance on kind of what that means. And then second is also, sorry?
Andrew, if I could chime in, I think some of the questions I've been getting, and I'm sure maybe you can say if it's the same feeling with you guys, is that, a lot of the question comes because people are trying to poke at these requirements thinking, is this too good to be true? Like, where's the catch? How come I can get this money? And the intent of reading the legislation, I think a lot of the documentation is geared towards fraud because it's such a simplified process that it's ripe for fraud. But, absent fraud, I think that we can anticipate some very, helpful clarification that's forthcoming.
Right. And then the other kind of point on the certification is just as to the use of the funds. We'll talk about that a little bit later, but there are certain limited uses that you can use it for in order to get loan forgiveness under the program. So how much money can you get for a loan under this program? So how it's calculated, it's based on 2.5 times your average total monthly payroll cost over the prior year, or $10 million, whichever is less. We think, based on most of our conversations with clients, we're probably going to be on the lesser side, just given that small businesses aren't going to have that large of payrolls, or most will not. There are some special rules if you were not in business in 2019, and also for certain seasonal employers. We would also like to point out that there are here this word payroll cost. There's a specific definition of what is and what is not included in payroll costs. And one of the primary questions that we've got on it is in terms of the amount of compensation. Under the definition of payroll costs, a compensation for an individual which is in excess of $100,000 on an annualized basis is excluded. Based on some additional Treasury guidance, it's states that that's really a cap. So if you're an employee, have an employee making $105,000, that doesn't automatically kick them out of the calculus. It's just going to put that cap at $100,000. So amounts over that are not going to be included in the calculation.
This is Rebecca, and one thing I want to point out that I've had a lot of questions on, and the definition of payroll costs in the statute covers not just cash compensation, but you're looking backwards 12 months prior to the loan. You're looking at average of all cash comp, including vacation, sick, severance payments. You're looking at group health benefits, including insurance premium costs. You're looking at the cost of retirement benefits, and you can't count social med and federal taxes, but if you had employer portions of like state and local taxes, you can count that too. And so that's huge. It's especially huge for some of my union clients that have fairly large contribution payments they make monthly towards the union pension and welfare funds. Those are payroll costs. So I just wanted to point that out.
No, I appreciate it. That's a good point. One other point here to note that kind of is somewhat of a recent development given some of the Treasury guidance. Under the statutory language, they have a 12-month look-back period based on the application Treasury guidance that was issued yesterday. It looks like the Treasury might be leaning towards looking at 2019 versus a strict 12-month look-back period, but we're still looking for a little bit more definitive guidance on that. But that's just something to be aware of. As I mentioned earlier, the amount of loan proceeds can only be used for certain purposes, and here we have a list of the permissible purposes. Here, primarily payroll costs, as well as Rebecca had mentioned, some costs related to other employee benefits matters. So as was indicated earlier, up to 100% of the principal amount of the financing of a loan through this program is eligible to be forgiven. There's a few stipulations here that we'll go over, but generally speaking, in order to calculate the loan forgiveness, you're going to look at the amount of eligible expenses which were incurred and paid by the business during an 8-week period beginning on the date of the loan origination. The potential amount for loan forgiveness are a couple potential reductions to be aware of that relate to employment. The first is based on the number of employees. The CARES Act provides for a proportional reduction in the amount of loan forgiveness you can receive in the event that your number of employees during this 8-week period is less than the number of employees as compared to an earlier period as provided in the Act. And then second is also if there's been certain decreases in the amount of compensation. A couple of points on this. It only applies to compensation in excess of 25% threshold levels. And this second, the compensation rule also only applies to employees which during no pay period in 2019 did they make an annualized salary of $100,000. So it's not going to apply to everybody. So, but there's potential for reduction there. And then one other.
Andrew, if I can chime in, because I know it gets confusing for everybody. And one thing I saw on the sample application yesterday that kind of helped me simplify the explanation. And I know it's risky of being an oversimplification, but I think it's helpful in understanding all this. It's basically think about, you have to use 75% of the loan money towards what they consider payroll costs, or else you jeopardize the amount of forgiveness you have, period. So do you think that's, I mean, that's how it was worded on the instructions. And so I think that's a help. It's not the same as how the statute words the calculation,
Right.
but I think it's a good way of like kind of simplifying the process to wrap your head around some of this.
Right, and that was a new development. It's, you know, Rebecca, as you said, that was not in the act, but due to the expected high subscriptions to this program and kind of the intent in it being to keep people on payroll and pay for payroll costs, the Treasury has indicated that up 75% of your amount of loan forgiveness that you're seeking needs to be for payroll costs, and only 25% can be for these non-payroll costs, such as interest on existing mortgage loans, rent, and then as well as utility payments. And then in terms of, well, how do I get my loan forgiven? After this 8-week period, you will have to submit an application with appropriate documentation and certification to your lender. So as you are going through this process, if you have taken out a loan, you want to make sure you're diligent about keeping all of your payment records in terms of both payroll as well as, you know, checks and utility bills and anything else to document your costs that you have paid with these loan proceeds.
Andrew, this is John, and I think that drives home a point that your relationship with your banker is important here, because it's not the SBA that will be determining whether to grant the forgiveness. It will be the bank. So again, you know, call your banker early, get in front of them, make sure that they know you're working with them and that you feel they're working with you, because they're going to be the ones to say you don't have to pay this back.
In the event you have a loan and only a part of the principal amount has been forgiven under this program, the remainder of it will be still subject to a general unsecured loan. The Treasury Department issued some guidance yesterday saying that all loans under this program are going to have the same terms regardless of who the lender is or who the borrower is. They've also set the maturity of a 2-year term and also fixed the interest rate at 0.5%. They also set forth that loan payments will be deferred for the first 6 months after the forgiveness period, but interest will accrue. But you are able to pay this off whenever. There's no prepayment penalty like many other debt instruments. And then here we just have a couple of pieces of information that was provided yesterday. The Treasury has said that small businesses and sole proprietors can start applying for these loans as of Friday, or as of this Friday. However, as John mentioned, banks are still looking to get some more guidance, so that might be a little bit of a hindrance, even if people can actually file these applications. Based on conversations we've had with some people in the industry, that we're hoping that the Treasury or SBA issues some additional guidance to financial institutions by the end of this week. So hopefully that things can get ramped up, early next week. And then also here, the link on the screen, if you go to that, that includes the additional information that the Treasury Department issued yesterday. It has a little bit of kind of like FAQ type information, as well as the sample application that John had mentioned. So you can kind of print that stuff out and start compiling information based on what's on that sample application to hopefully get yourself in a good position for getting this on file and process in a timely manner.
Andrew, I have a question that came through that I think applies to a lot of people. It's what are owners' salaries considered in this? And my understanding is that it is a payroll cost. If you're receiving that's the whole point of covering small businesses and sole proprietorships. that right?
Yeah, and
Do you agree?
I think we're still waiting on a little bit of clarification on that, but I think if there's a W-2 payment,
Right. That helps
then
a lot.
right, that might be different from if you are for example, member of a LLC and are just taking a distribution. But we are hoping to get a little bit more guidance from the Treasury on that specifically, because we've had a few people with that question as well.
I know, and I saw under the statute for the people listening, like there's different provisions and calculations for sole proprietors and small businesses, and it doesn't overlap necessarily with payroll costs in terms of disbursements. So I think that's what Andrew's alluding to, getting clarification on, but it should be factored in some way. And that's all. I had another question about furloughed employees, and you know what? I can bring up some of this when I talk in my section about Families First
Right.
and bringing people back. So I'll keep that one for later.
All right, yeah, that's fine. Yeah, I don't think I think I skipped over that, but real quickly, the two reductions that I spoke about in terms of loan forgiveness with respect to employees, the number of employees and salary, there is a potential to cure or eliminate that reduction if it's done prior to June 30th of 2020. The next topic is what we wanted to briefly highlight. It's another SBA loan program. It's a disaster loan program based on the coronavirus of President Trump. He had declared a national emergency earlier in March now, and to make people that are adversely affected economically by the COVID-19 crisis to qualify for these economic disaster loans through the SBA. Generally, these can go up to $2 million in funding. They are not eligible for loan forgiveness like the Paycheck Protection Program, but it's another possibility if you need funding to cover some costs. A couple things we would note is that there is some expanded eligibility, similar to how it is under the Paycheck Protection Act, to include businesses with not more than 500 employees. There is also the option for an emergency grant of up to $10,000 if you have a application for a disaster loan on file. They said, will be distributed in 3 days. I think this is important if you are applying and need some funds sooner, because the disaster loans, unlike the Paycheck Protection loans, those are going to be through the SBA, and it's going to take a few weeks for that process to kind of go through the SBA's normal process. So you're looking at probably a little bit longer time frame there, and a little bit more cumbersome application process. In terms of comparing these, one thing to the Paycheck Protection Program, one important thing to note is you can't double dip and have a Paycheck Protection loan and as well as a economic disaster loan for the same purpose. And by that I mean the Paycheck Protection Program is primarily designed to cover payroll costs. You can't also take out a economic disaster loan to cover your payroll costs. They're just trying to prevent businesses from double dipping and taking advantage of both programs. With that being said, if you've taken out a disaster loan for a different purpose, you can still qualify under the Paycheck Protection Act, and you would have the ability in certain instances to refinance your disaster loan into the loan under the Paycheck Protection Program. And two other tax-related matters that we wanted to cover that are part of the CARES Act. These are, if you do get a loan under the Paycheck Protection Act, you're going to be excluded from these, but these are some potential alternatives for employers who might exceed that 500 employee threshold and still be able to get some type of assistance in this time. The first thing we want to talk about is the Employee Retention Tax Credit. This is a tax credit to payroll tax for employers impacted by the COVID-19 crisis. This is based on 50% of qualified wages up to $10,000. So you're really looking at a maximum of a $5,000 per employee credit for wages paid from March 12th through the remainder of 2020. To qualify, you need to be an employer whose business was shut down due to a government shutdown order that we've seen in a lot of states so far, including in Indiana. Or if your gross receipts are less than 50% as compared to the prior quarter, you would be eligible. One other important point is that in determining the amount of qualified wages, if you have more than 100 full-time employees, qualified wages only includes wages paid to employees who are not currently providing services. This same limitation does not apply if you have less than 100 full-time employees. And then last but not least is the payroll tax deferral. This allows employers to defer the employer-only portion of payroll taxes for the remainder of 2020. And just to clarify, this applies to the Social Security component, not Medicaid. But how this would work is you can have it deferred and pay 50% and repay 50% by the end of 2021 and the remainder for 2022. This is also available to self-employed individuals, but you are only entitled to take 50% of the payroll tax and defer that. So I think I'm going to hand this back to you, Rebecca, if Larry wants to kind of start talking about the other loan programs through the Treasury.
Thank you, Andrew. This is Larry Tallman. Rebecca, if you could advance one slide for me, please. Can you hear me?
Yeah, we can hear you, Larry.
Okay, I'm sorry.
Advance the slide.
All right, thank you. Title IV of the CARES Act, which is known as the Coronavirus Economic Stabilization Act of 2020, created essentially two buckets of money. The first of which is $454 billion, and the second one is approximately $46 billion. The difference between these two buckets is the $46 billion bucket is programs where the Treasury is going to be lending directly to certain specific industries, to air carriers and to companies that are essential to national security. The rest of the money, the $454 billion, will be distributed through the Federal Reserve to mid-sized and larger businesses. If you could go one slide. The qualifications for this program, for the Federal Reserve programs, are pretty broad. Essentially, you have to be a U.S. business with between 500 and 10,000 employees. And I'm going to fly through these slides so I can get to the really important ones at the end. If you could advance one. What the statutory language says is that the Federal Reserve shall endeavor to seek to implement a program for mid-sized businesses. That means that the Federal Reserve has not fully formed the terms of this program yet. I set forth what we know so far about the program, but what's conspicuously absent here is the requirement for any equity investment by the Federal Reserve. You recall in TARP a couple of years ago, and in the other Treasury program, there's a requirement for the issuance of warrants or preferred stock or a debt instrument. You could advance. All right, here's the hook to this program. Essentially, in order to participate in the program, you have to make 10 different good faith certifications. The first two on this slide are essentially non-events, but from there on, the workforce matters, and then on the next slide, the dividends and stock repurchase matters and the labor matters get important. I've spoken to a number of businesses, and at least one or two of them have told me that, you know, they're questioning whether to take the money or not because of the way that it ties them up. If you could advance 2 slides, please. Thank you. Here's the Main Street Lending Program. This one is truly aspirational. The Federal Reserve doesn't have any guidelines for it yet. They're planning to create this program in the future. If you could go one more. The second Treasury program is designed primarily for air carriers, passenger air carriers, cargo air carriers, and businesses that are critical for the national security. So I suspect that many of the people on the phone today probably don't or would not participate in this program, so I'm not going to cover much here. But I do want to touch on a few things that I think are important. If you could go one more on slide. This program, one of the things that's unique about it is it does not have to be a secured loan. You can trade interest rate or lack of security on the loan. In other words, take a higher rate loan and not have a secured loan. And unlike the loans that Andrew spoke about in the Paycheck Protection Program, this loan is not forgivable by the Treasury. And then if you can go one more slide. Again, in this program, here's the hook. There's certain restrictions on employment levels that you've got to maintain, essentially your employment levels as of March 24th, 2020. Covenant not to reduce more than a certain level. And then you have restrictions on stock repurchases, dividends, capital distributions, and then on compensation and severance payments. The one on the compensation and severance payments is where this becomes somewhat problematic for some business owners, limiting the amount of money that they can take out of the business. And one more slide. And here I mentioned the other program with the Federal Reserve did not require an equity investment by the Federal Reserve. This program, similar to the TARP from a couple of years ago, does require that anybody that participates, if they're a public company, they have to issue a warrant to the Treasury. If they're a private company, non-public, they have to issue a debt instrument. And if we go one more slide. All right, here's what I was rushing through to get to. This guidance came out day before yesterday from the Treasury on the specific Treasury program for the airline or for the air carriers and national defense. Now, admittedly, that is not the program that most of you will be in. But what I think is important here is this is the guidance that the Treasury gave of the types of information that people who plan to apply should be compiling today. Now, some of this won't apply to you, things that are specific to air carriers such as cargo rates and all that. But I think it would be prudent to go ahead at this point and take this list, this page and the next slide, and start compiling that information and have it in a folder ready so that when the application for the program comes out, that you'll be ready to apply.
Just a reminder, Larry, if I can interrupt, just a reminder to people that the slides will be going out in our thank you email, so they don't need to be taking crazy notes right now for ideas of what to get together for documentation, that they will be receiving a copy of our PowerPoint.
Great point. Thank you for bringing that up. Because this slide and the next is an extensive list, and as you go through it, it's actually quite a bit of information to compile. And though we don't know for sure, we think the other program will likely have similar requirements. If you could go ahead, 2 slides. I'm sorry, back 1. Here's the other important piece. Now, I've listed a number of things here, relief that the Treasury and the Federal Reserve has given to community banks. I don't expect you to be interested in those. I listed them solely to illustrate the magnitude of the lengths that the Treasury is going to to facilitate lending by community banks. They've really released them from a lot of obligations. So every bank that we've spoken to is ready to have that conversation with you about lending under these programs. The advice that most of the bankers have shared with us is to call them sooner rather than later. And I think John made that point in his opening remarks as well. A number of banks that I've spoken to personally have said that they're keeping a list of their customers who have called, and when the program comes out, they're going to return calls in the order that they received them. So obviously, the sooner that you get on that list, the better. In terms of what they're doing right now,
Larry, excuse me for interrupting for a minute. There are some banks that are also saying that they're only, because they have limited funds at this point, they're saying they're only going to make these loans to existing customers. So call the bank that you got that relationship with. Don't call one you want to start a new relationship with. Sorry, Larry.
Oh, no, thank you very much. I appreciate you putting that in. Would you mind also sharing some of the feedback that you've received from banks in terms of what they're offering customers as an accommodation now?
What we're hearing is that because of this relaxation by the banking regulators, if you have outstanding indebtedness, go talk to your banker. Again, use the same information that we said you're going to generate for your existing loan, but show them like your last 12 months of operations, show them your 12/31 financials, show them your Q1 financials, and tell them, give me 90 days, give me 3 months of deferment. And what I'm seeing a lot of banks do, they can go up to 6. Most of them are right now saying 3. We'll see where we're at in 3. Then we might do another 3-month deferral. And some are saying they're just going to push the term of that loan out 3 months if it's a 3-month deferral. Others are saying it's still going to terminate at the same time, but there will be a balloon payment at the end. So, that's kind of a bank-by-bank call. But I think it's important to go, if you're going to go ask for the PPP, ask if you can get a deferral also. Because if you think about it, the PPP is got a 6-month deferment on those payments. And if you get a 3-month deferment on this, your cash flow is going to be so much better, and it might get you through, the slowdown that we're hitting here. So those are the main points that we're hearing, Larry.
All right, great. Thank you very much. And Rebecca, I will turn this back over to you.
Okay, I'm bringing up the last leg of this marathon webinar race to get you through all this information. And I just want to say, I hope that some of you have I know webinars can be boring and you're learning about the law, which, maybe for some people aren't so dorky like me and it's not so exciting, but hopefully that this webinar so far is bringing you some positive ideas and solutions to help get you through things. It was challenging the past couple weeks because a lot of it was focused on how to cut people's pay and how to lay them off temporarily or permanently. And now we're focusing on how to get you money so you can continue wages or bring them back or do what you need to do to continue their wages. And that's exciting, I think. So what I want to do is talk about some additional things in designing those compensation programs for your people. First of all, I don't want any of you to forget about Families First, especially because Andrew mentioned you can't double dip, right? So don't forget, if you're under 500 employees and you're eligible for the Paycheck Protection Program, that you still have to deal with the Families First rule for the paid leave. And that's the 80 hours of paid leave if, someone has to be quarantined or they get sick with COVID-19. It's the 12 weeks of expanded FMLA leave if they have to, at 2/3 pay, if they have to take care of a kid that's not in school, things like that. If you don't know about Families First yet and you're under 500 employees, you need to get caught up because it started today. It went into effect. And if you need that, we did do multiple webinars on that. It seems like ages ago, but it was only maybe last week. And, yes, there's been further guidance since then. So, those recorded webinars we have available with the PowerPoints, they're still there. We can send them to you if you request them and email us. But, there's additional guidance now on how to do that intermittently or other things, clarifications we didn't have at the time of the webinar. Just like I said at the beginning of this, things are constantly updated, but it still gives you a good overview if you're completely behind on learning about Families First. And then our blog articles, everything on I should mention, on salawus.com, our main website, we have the big Corona sign, and you can click on the task force, get to know us, and all of our blog articles our updates and our alerts are organized by practice group. It's a tremendous resource. We try to post some of our recorded webinar links too. You can find links to the email addresses of the attorneys in different groups, in different industries, but those articles should be very, very helpful if you want to drill down on anything in specific, including Families First, and get some, every update they've had, we've written an alert on it, so it's there. What I do want to mention is that you're getting a payroll tax credit for this leave. So if you're giving that out, you can't then double count that and count that towards a forgivable payroll expense, because it's not considered a payroll cost if you're otherwise getting a credit for that compensation through Families First. Okay, unemployment. Will your people want to work anymore? That's the question. So state unemployment doesn't cover everyone. It doesn't cover certain situations. It doesn't cover, to put it generally, it doesn't cover if you're not otherwise available to work. Most states have expanded those programs to cover you if you are required to stay home to care for a child, for example, because they're deeming you otherwise available to do an at-home job. So those people are at least still getting unemployment and things like that. If you're an independent contractor, you don't qualify for unemployment. So CARES enacted a $600 weekly stipend in it's a pandemic supplement for up to 39 weeks. If you do qualify for state benefits, you get the $600 on top of your state benefits. If you don't qualify for state benefits because you're an independent contractor, for example, then you just get the $600, but it's still $600 better than you got the week before, right? So you get at least some funds. Now, I want people to understand and do this math, because sometimes I have employers say, wait, what? I don't get it. So Illinois is an example, and then these are ballpark numbers because it's, a specific dollar amount is the maximum, and it's over 400. But the maximum unemployment in Illinois is around $400, and it's capped. It translates to somebody making $40,000 or more is going to get the maximum weekly benefit. If you have dependents in Illinois, you get additional allowances. If you have a dependent, I believe it's $105 or something, but for simplicity purposes, I rounded my numbers. So this person in Illinois is a max for $40,000, $45,000, $50,000, doesn't matter, gets $400, has a dependent, gets $500, is now going to get $600 as a pandemic supplement. So that means their weekly benefits are going to be $1,100. And I think it's important to point this out, especially if you are one of these companies sitting on the phone thinking, oh, great, I don't get the Paycheck Protection Program. And it's like, Santa forgot you on Christmas morning, because that's a really sad thing if you're left out of that. But this is a thing to think about and say, okay, unemployment is not the devil. It's not awful. If people really understand how much they're getting, either way, people are getting government money to get salary continuation, whether you're facilitating that as an employer or whether they're getting directly through unemployment. And, if you have people around that 50,000 mark, it should take that weight off your shoulders of having the whole burden of continuing their wages on you. There's also ways you can continue their health care benefits during that time if you can afford it. And, then that helps. It helps in terms of managing this hopefully short-term situation we're in. Very short-term situation. Let's be positive. Anyways, so that's the benefit. The one question, and I'm going to talk about 139 payments in a second, the one question that leaves you with is I have some companies where they're an essential business and they need their people to come in and they think, oh, great. Now what keeps them from just saying, forget it, please fire me. I can't come in. I want unemployment instead. So we got to think about that as well. Okay, so 401k provisions are expanded, another tool for your employees. And this is, for any company that has these benefits. It applies to 403B, 401K, and IRAs. You can take a distribution up to $100,000. Normally that was $50,000, I believe, and now, and only for certain reasons. That hardship distribution has been expanded, the definition, to include COVID-19 disaster-related needs. So if you lost your job, if you were laid off, if you have other issues, you can, if your spouse lost their job. They haven't come out with any specific guidance on what makes it COVID-19 related, but it's presumably going to be pretty broad. The neat thing is you don't pay the normal 10% excise tax that's imposed on early distributions. And I think a neat tool that makes this a neat tool in your toolkit is that you don't include the immediate distribution in your current year taxes. So you're only taxed on a third of it. So say I wanted to take out $100,000 from my 401k because the market's not doing amazing right now anyways, and I'm just losing money. So I take out my $100,000. I pay tax on $33,000 of it. At the end of the year, I didn't need that money. I can put the $66,000 back in my 401k funds with no ramifications. I think that's a huge tool to kind of give yourself that cushion or have employees know about that. The other tool is that is twofold. One, the maximum loan amounts you can take under these programs have increased to $100,000 from $50,000, and the payments under even outstanding loans. So if you have people with 401k loans right now that are taking a big chunk of their paycheck, you can give them the option of stopping those loan payments and deferring them another year. It should be at the employee's election though, because it's their own debtor and collector and all of that good stuff. But you do want to be giving your employees that option if they have outstanding loans, and if they take a loan now, to be able to defer that until 2021. Then the one thing I want to say is, you have the required minimum distributions you can delay if you have employees in those older categories. They want to leave their money in maybe because they want to give it a chance to recover from everything that's just tanked. The cool thing is that you can start operating with these provisions right away. The plan amendments for these provisions can be retroactive. So that means you can communicate to participants and start operations, work with your third-party administrator, and then you'll be able to do your amendment. The rule is written, because nothing's ever written simply. The rule is written, or the statute is written to say it must be adopted by the end of the plan year beginning on or after 1/1/2022. For most of you with calendar year plans, this translates to a deadline of December 31st. Because that's me, I like to simplify it. December 31st of 2022, not even the current year. So finally, to wrap things up, I want to talk about qualified disaster payments under 139. Now, one thing I want to point out in talking about these, they have to be, these are not payroll expenses because they're not income. I'm going to talk about that in a second. So they have to be three things. They have to be designed to be reasonable and necessary as a result of the qualified disaster. Again, that's broad. There are very few regulations on what qualifies as a 139 payment, because this provision of the tax code is only triggered when we're in the midst of a disaster. And this tax code provision was triggered on March 13th when President Trump invoked the Stafford Act for that purpose. So this provision was invoked at that time. There are no caps on the amount of the payments you can make under this. No discrimination requirements to be met, like with your 401k plan. You just can't make them income replacement, right? This isn't a way to substitute wages. You can't just do sick and vacation and wages and call them disaster payments. They need to be, it's expense reimbursement without the documentation, okay? So I have some companies that say, okay, here's another $250 so you can go outfit your home office because we need everybody to work from home, beginning yesterday. Or here's an extra $100 a day to help you with daycare expenses. Or here's an extra, or we're going to lay you off, but here's another, $300 a week to help you with food and lodging expenses. You don't have to have that reimbursement. That's what the no documentation refers to. And you don't have to have a formal plan document. So that's a big deal too, because it makes it a lot simpler. One thing I want to say though is because it's not income, there's, this is a pro and a con, right? The pro is that you can use these to supplement unemployment programs because it's not income that's going to offset or be reported to the unemployment office. It's not going to be on your payroll. It's not going to be taxable income to either you or the recipient. But as a business, you can still claim it as a deduction on your tax return. So that's a bonus. But the offset, or the downside, I guess, that I want to leave you with is that you can't learn about all these great things about the payroll protection program. Well, since this isn't payroll, you can't use PPP funds to make then disaster payments. It would be a form of double dipping. So with that, I want to let you see our, beautiful pictures so you know who's explaining the rules to you this morning. And our email addresses, our phone numbers, if you want to reach out. I will say that, let's see here, we have a long slew of questions here, and I think if yesterday my colleagues would indulge, we can start to go over some of them. Yesterday it was maybe 15 minutes over that we went, so if you want to stay on and listen to the answers to those questions and that discourse, you're welcome to do so. And if you don't, then that concludes our presentation, and watch for the slides. All right, are you guys ready? If you can, the other panelists can unmute their phones so I can make you help me on these questions. Hold on here. I will be in charge. So the first one is, does PPP loan restrict dividends? Articles state that no dividends for 1 year after payoff, and if so, does it apply to pass-through entities such as an LLC? Our concern, we could show profit but not be able to distribute to LLC owners to pay their taxes. Can someone help me with that question, John or Andrew or Larry?
Yeah, I can. I think maybe what some of the articles might be referring to are some of the Title IV programs that Larry spoke about. There's nothing about that under the Paycheck Protection Program.
Okay, and one thing, and that's a good thing to point out, Andrew, because I'm getting that a lot. When I get questions with snippet bits, it's really hard because you read articles and sometimes they're focusing on one provision, and it's easy. There were a lot of different things under the CARES Act. And all these different programs still fall under that umbrella. Absent 139, everything else we talked about today was under the same statute. So it's very easy to read snippets and get confused. So it sounds like that would not apply to the Paycheck Protection Program. Earlier, it was mentioned that it is possible that temporary labor could be considered payroll. How will we determine this, or what is the criteria to check against it? It's my understanding that we don't have the clarification on that. We have this wording in the statute that says, you count all your employees full-time, part-time, and other, and we don't know what other is. Do you guys understand? Do you have any clarification, or have you seen anything else come out?
Yeah, I can chime in on that. There hasn't been anything specific to the Paycheck Protection Act that has come out, but under the SBA's regulations that are generally applicable to business loans, how they calculate that is they would include temporary employees. They also would include, part-time employees, and then they also apply a totality of the circumstances test to potential, like contract workers who could be brought in under the count as well.
And Andrew, there's a question about how do you treat 1099 employees? How do you treat subcontractors? Why don't you talk about that a little bit. There's no 1099
employees. I'm a freak. There's no 1099 employees.
Whatever you want.
I'm stickler
Andrew,
about that because I'm always defending the 1099. But I know what you mean. They're counting them as employees under the statute. It's hard because they're not supposed to be, but they're counted.
Right. I think what we're really waiting on is for some additional clarification because, in the one sense, under the Paycheck Protection Program, independent contractors, for example, are eligible to get a loan. But at the same time, if they're, if an employer who employs somebody on an independent basis or employee or a contract basis were to include them in their headcount, it's kind of like double counting that person. So it's not exactly clear how that would play out at this point.
Right.
And
for
on
now,
those
I've
lines,
been telling people to communicate with their contractors because you could be hurting them. I mean, 25% of these loans can go towards other costs, and they might need those other costs. And if you count them, they might then be precluded. So
right.
we don't know yet.
Well, and along those lines, I know we talked about it earlier, but the SBA is targeting to have additional guidance out Thursday or Friday, but they're also saying that that's, could push to Monday. But hopefully we'll have answers to those types of questions very, very soon.
It'll probably be John during the midst of another one of our webinars, and then we'll have to update like immediately after.
There you
like
go.
yesterday. Okay. Let's see. What's the other one? In regard to the Paycheck Protection Program and EIDL, would it be possible to use the PPP loan forgiveness to forgive payroll costs and at the same time use the EIDL 10,000 loan grant to pay for things such as rent, mortgage, and utilities? I think that this one is going to depend on specific numbers. I don't think that's something we can give general advice to. Would you guys agree?
Yeah, I agree.
Yes.
It's too hard because you're looking at overall costs, and your EIDL could end up being refinanced through the Paycheck Protection Loan, and then you're still counting that in the calculations. So I don't know that that's something we can, it would depend on your specific calculation. Next question, regarding payroll costs, how are subcontractors, I think we answered this. How are subcontractors or 1099s treated with regards to this 2.5 calculation?
Yeah,
for example, my company uses a larger company. Yeah. What if it is all used for payroll, but your company still has to lay everyone off because there is no business? You still have to repay the loan because you didn't retain the employees. I don't understand this because if you're using it for payroll, then your people are retained.
Right, and
so
I mean,
if you don't,
even if there's no work for them, I mean, that's kind of the point of the act, is to keep people
right.
on.
And if you
payroll.
don't, right, and if you don't, and you can't correct it by June 30th, then you just have to. It's a loan. It translates to a loan at two years maturity, which I don't understand because the statute said 10 years, but I know the rules that came out yesterday said 2 years maturity and 0.5% interest, right?
Yeah, and I think
Right.
Rebecca, the statutory language were upper threshold caps, and the Treasury exercises regulatory discretion to say what the terms of the loans are going to be.
How nice of them. Anyways, 0.5% is still pretty darn good. Let's see here. Are state and local government entities deemed covered employers under the CARES Act?
I'm sorry, could you repeat that, please?
Are state and local government entities deemed covered employers under the CARES Act?
There is going to be a program, I'm not certain whether they participate in the PPP, but there will be a program under Title IV for government, state, and municipalities.
Right, there's different funding under CARES that we didn't cover today because they're not a for-profit business under the SBA guidelines otherwise.
Right,
Or
and at this point,
501c3.
none of the guidelines for the state and municipalities have been released yet.
Okay. What is the look-back period to determine the number of employees for the monthly average? I think we answered that in terms of, Andrew said the initial, and correct me if I'm misquoting you, Andrew, you said the initial rules looked at 12 months prior to the loan disbursement, but the new guidelines that came out make it seem more like it's going to be 2019 calendar year look back, right?
Right.
See, I listened to Andrew. Let's see here. Am I eligible for unemployment if I own a business and draw a manager's salary? My answer to that is yes, because it applies now. Well, you're eligible for the federal pandemic supplement, but probably not your state benefits because self-employed people do not get unemployment. through state programs right now, unless that's changed in the near future. But you would get the pandemic relief because it qualifies sole proprietors, independent contractors out of work. But again, remember, you can't double dip. So if you're getting that, you can't get that and then claim your, and pay yourself. The payment would offset the benefit eligibility. Is the CARES Act in effect now?
Rebecca, let me back you up just a minute because I got another question that came through. Is the unemployment tax credit under Family First of it, if they take advantage of that, are they still eligible for a loan under the PPP?
Okay, under Families First is different than unemployment. So if you get unemployment, then you're getting that benefit. And if you're getting wages paid to you through Paycheck Protection, then that's going to disqualify you from unemployment eligibility because you're not unemployed. You have wage continuation. If you do Families First, that works in conjunction with PPP. So you still, you're going to be required to fund Families First paid leave requirements. Those have caps. So you have caps of, say we're at the 2/3 amount, up to, 2/3 of pay up to 12 weeks. That's capped at $200 a day and $2,000 in wages, and that's all the tax you get. So you would use then the Paycheck Protection Program funds to supplement the difference if you want to continue pay for your people and max them out to their full pay. Because the tax credits don't cover 100% of salary continuation under the Families First. And even the first 80 days, 80 hours, not 80 days, that are covered for sick leave and things like that under Families First, that's maxed out at something like $500 a day. So you would use the difference in funds to deal with that shortfall. Does that answer the question, John?
Yeah, it does.
One thing I've had a question on is somebody I was talking with this morning was looking at the timing of when he wanted to access the Paycheck Protection Program for that reason, because, he was not certain how long this would last, and it covers 8 weeks of your operations, and you have these other benefits that can kick in. So I really think it's good to try to get a handle on how it all interrelates, and, that's what we're here for, but to try to get a handle on how it all interrelates so that you know how to maximize the available options.
Exactly.
What is the other one? Let's see here. Is the CARES Act in effect now? Yes.
It's in effect now, but the programs under it are not
what they're doing.
up and running yet. But hopefully they will be very, very soon. Yes.
Well, because things like the unemployment provision, it goes retroactive to a January date. If you filed for unemployment, it's going to go retroactive to that. But the people on unemployment right now, they're not getting the funds because the money has to, the states have to figure out how to go back and calculate those amounts and get it from the federal government to distribute the funds. So
right.
So they're still sorting it out, but yes, it is. There are effective dates on the different provisions that are in effect right now. When your employee who has to stay home to care for a child, they can't go to school. It's our last question, I believe. That can't go to school, does that unemployment go against the employer and then raise their rate? You know what, that's a really good question, and I get that a lot. Unemployment programs vary by state. So this is a state call, and I will tell you this. So far, Illinois is not is contemplating. I believe in their FAQs they published that these period they're not expecting to implicate experience ratings for employers. But that said, your unemployment rate in every state is comprised of a multitude of factors. It's comprised of an overhead factor. It's called the building rate in Illinois or other states. It's comprised of an industry rate, which means are you an industry subject to high turnover? And then it's comprised, your experience rating factors in. So your experience rating is one of many factors that comprise your unemployment rate. And in these times right now, I really don't think that impact on your experience rating, even if the state hasn't made a determination, that should implicate in your strategic planning and your compensation decisions. There's enough to get hung up on and try to figure out how to coordinate. So, gentlemen, do you have anything else you would like to add?
I don't. Thanks, Rebecca.
Nothing here. Thank you.
I think we've wrapped up. I think that's the questions. So I want to thank everybody for joining us today. Very good questions. I hope we got yours answered. We will be sending this back out to you, the slides, as Rebecca mentioned, later today. If you have any questions that didn't get raised today or weren't addressed to your satisfaction, please send emails to us. That will be, our addresses will be on the slide, so please reach out to us or one of your other Smith-Thompson contact attorneys. We'll get you through this. As I said at the beginning, these are scary times, and this is an almost 900-page act, but it does have things in there that can help us, and what we want to do is help you figure out what those things are. So I want to thank you for taking the time. I hope this was worth your time, and I hope it does assist you in your business. Thank you very much.